Legal Services of North Florida is a civil legal aid organization, which means we provide free civil legal assistance to low-income and vulnerable clients in the Florida Panhandle. So we're not just in Leon County. We go all the way over and through Escambia County, starting at Jefferson, actually. So all 16 counties in the Panhandle is in our service area. And so we do things like if you have a problem with your landlord-tenant, evictions, housing, foreclosures, domestic violence, divorces, dissolution of marriage, custody, all kinds of civil legal issues except for like personal injury. So if you slip in the store on a banana peel, you will not come to Legal Services in North Florida. You will go to what I call one of those advertising attorneys. And you all know who those are because they're on TV plenty of time. But if it's some other civil legal problem, we may be able to help you. But today we were asked to be here to talk about Heir property. And we put together a very low-tech presentation. We went old school with the flip chart today. And so we're flipping it along and starting with question number 1. What is Heir property?
Can you bring it closer?
Yes, ma'am. I can do that. And if you come out to where we're sitting outside when we're over, if you haven't been there already, I need to talk in the microphone. I always think I have a very loud voice, right? Because I taught school at some point, and so I'm used to talking to the kid in the back who's trying to make sure he's not seen or she's not seen. But if you come by our booth, we have a pamphlet there that talks about Heir property and why you need to clear title to your home. That'll go over some of the things that we talk about today. Okay, so what is Heir property? Well, it's a home or land that passes down from one generation to the next generation just informally. So there's been no formal transfer of it. It can be passed down through several generations so that there are multiple owners that own one piece of the land. And so, how is it created? Just that way. Somebody started out owning that property. And then when they passed, maybe they didn't have a will, or they had a will and that will was never probated, and so it just passed down to the next generation. And then maybe they didn't live in it, or one of them lived in it. And then that person died, and then it's passed down maybe to their heirs, or it's passed and it's still up in the multiple other people's names. So it's not unusual to have heir property where you have, when I say multiple, I mean more than 3 or 4, 16, 17. When I first started practicing, I was working in Gadsden County, and I had a case where we had 129 heirs. So that's a lot of probate. And so it's a good to catch it way before you get to 129 people. So, Jessica, you want to talk about different types of ownership of
Sure,
property?
yeah, absolutely. All right, good afternoon, everyone. So there are 3 main types of ownership that we see quite often. I'm going to tell you about the first one, which is tenants by entireties. And this is basically, when a husband and wife co-own a property, it becomes, they become tenants by the entirety, which basically just means the marriage owns the property. If one spouse passes away, then the other spouse takes complete ownership of the property. And then next we have joint tenants with right of survivorship, which is in a way similar to tenants by the entireties, but instead of a married couple, you just have individuals that are either related or unrelated, depending on how the language, is written. But essentially, the language written to set up this ownership states that when one individual passes, then ownership passes, to the surviving individual. So then last, and this is probably the most common one we see, is tenants in common. And what this means is basically the property is owned by more than one individual, and there's an equal interest for the most part. But when someone passes away, that ownership does not pass on to the other co-owners. Basically, their ownership interest, is inherited if there's not a will or in accordance to that person's will, if they had one set up. So does that seem pretty clear? Any questions?
Not exactly the last one.
Okay. So if you have tenants in common, and we're going to go over a scenario that will kind of clarify tenants in common as well. But basically, when you have a property that is owned by tenants in common, if you have one individual, one owner, and one co-owner who passes away, their ownership does not pass along to the other co-owners necessarily. So it either their ownership interest passes through it passes along to their heirs, or if they have a will, their ownership interest passes per whatever the will dictates. Does that help clarify? Okay.
And it's that the tenants in common that really is what we're talking about when we're talking about the ownership that you have, if you have heir property. So like Jessica said, if there's two people owning it, they have it and they own it as tenants in common, and one dies, then whoever is that person's heirs, decedents, they get the property. And I'm going to show you this on a chart here. And the other one still has, they have 50%. And then the heirs of the other one has 50%. So if they have 10 heirs, those 10 heirs divide up the 50%. So it gets complicated. In Florida, and Jessica's good at the probate, is that when we die without a will, our property goes to our heirs. In some other state, I call it going up. So it goes back up to if you don't have a will, it goes back up to your parents. Florida, it goes down to your children, generally, if you have children. And then if your children don't have a will, then it goes down to their children, your grandchildren. And so that's kind of what you see in this example of a heir property. Okay? And I'll have to say it because you probably can't read it. In the back. And I need to have the microphone. Okay, can I move it?
You can take it off the stand.
Oh, yeah. Okay. There we go. All right. So in this scenario, Pam and Peter own 100% of the land. And they had two children, Alexander and Ashley. I made this complicated when we did it because for some reason we decided to do it all alphabet. So everybody's... Okay, so Alexander owned 50% and Ashley owned 50%. And then they died. And so Alexander had a child named Benjamin and Beatrice. Ashley had Bianca and Brittany. So both of them died, and they had these 4 children, and when they died, each of them owned 25% of the property, okay, if they died, or even before they died. They owned 25%, okay? So you see how that happened, right? You went from 100, divided that in half. We had 2. They each had 2. They each got 25%. Okay, then it gets complicated because Benjamin, he's still alive. He still owes 25%. His 3 children, they own nothing because he's alive. And that was his part from Alexander because Alexander only had half from Pam and Peter. Beatrice is dead. So her 25%, she had 3 children, Cicely, Clinton, and Clifford. So they own, I know I shouldn't have done that. They own They own 8.3% each, okay? And then Bianca, she didn't have any children and she's still alive. She still owns her 25%. Brittany, she's dead. So she also had 3 children, and they each own 8.3%. But the thing that Jessica was saying about tenants in common is they own 8.3%, but you can't put your finger on that 8.3%, or you can't draw a circle around it because it's 8.3% of the whole. So each of these people who have an interest in the whole amount, but their interest is only 8.3%, or in this case it's 25 and 25 because they haven't died yet. So you can see how that might get pretty complicated. So think about your own family. If, for example, you didn't have a will. So for me, both of my parents are dead, and so I had 2 brothers, and so we would each have 33 1/3% of that. One brother passed. I'm making all this up. It's pretend, okay? So the one of my brothers, his 33% passed. He had 4 children. So nobody's done a will. So those 4 children have 1/4 of 33%. The other brother had 2 children. So they would have 1/2 of 33%. And then I have 1 child. He would be lucky and have 33%. But he would only have 33% of the whole. And so in the case of this one, Cameron moved onto the property, and nobody objected. You know, when the last parent or his parent died, maybe they were living, Cameron moved onto the property. And so even though he was an 8.3% owner, he still had the right, because that was 8.3% of the whole, to move on to the property. And so that's what he did. And then, this is how we see this problem a lot. A storm comes through, and the property is damaged. And so Cameron wants to go get some FEMA assistance. And then he wants to participate in Rebuild Florida and get that money for repair and assistance, because, you know, repair and replacement, because FEMA's only going to get your home back to where it's kind of okay. So Cameron, he could go to FEMA, and before August of this year, he would get nothing. He would not get repair money because he did not have title to his home. So he couldn't get anything. Probably Cameron doesn't have homeowner's insurance. That's why I went to FEMA first, because you're not going to be able to get homeowner's insurance unless you can show ownership. And if Cameron wanted to do something like fix it up on his own, because I'm going to go get a mortgage and I'm going to put a mortgage on the house, get some cash and fix it up, he wouldn't be able to do that because he can't show ownership. And so that's the problem that happens when you have heir property. You basically can't do all the things that people who have passed it according to law can do with their property. So it limits your ability. Also, what are we on now?
So we are on how widespread.
Okay. And there's more in here than I thought would be in here today, only when we get to this question about how widespread is heir property. Especially, I think you have the statistics for it. Do you?
So, you know, heir property is quite common, you know, especially in more rural communities, and also just in lower income communities. We see quite a bit of it. And essentially, you know, we've talked about what creates heir property, but, you know, we see, practically, we really see this play out when we have disasters, you know, and there needs to be repairs done that are pretty immediate and urgent. So, you know, some examples include In Texas, roughly 90% of low-income residents applying for hurricane recovery assistance had some form of cloud on their title. So, they had an interest or ownership interest in property, but they didn't have clear title. And so that prevented them from getting the assistance that they needed. In the aftermath of Hurricane Katrina, somewhere between 20,000 to 25,000 of New Orleanians had also clouded titles, which prevented obstacles for them as well. And in the 6 southeastern states that Florida is a part of, at least 85,607 properties are considered air property. So it's pretty common. Yeah.
Yeah, so when she was talking about Texas, the 90,000 people who had a cloud on their title, that was after Hurricane Harvey. And I don't know if y'all remember the pictures of Hurricane Harvey, but it was flooded. It was all flooded. And those people couldn't get any assistance from FEMA for repair and assistance. They might have gotten unmet need for some other personal items that they got, but would not be for repair and assistance. And the same for, of course, we all saw the pictures of Katrina, all those people who couldn't prove ownership and so therefore couldn't get any assistance. And so what happens then is people lose their property. And this is the problem. That people have had property in their home and part of their family for multiple generations. And you can see this. These aren't just made up things that happen. It's actually been in there for years. And when they can't repair it, that means the property is going to just fall apart. They may lose it because it'll be condemned, or they may lose it because no one has stepped up to pay the taxes or can't afford to pay the taxes. So you have to take care of this before there's a storm or before your house gets to such a condition that you can't afford to fix it, or the county or whatever organization or government authority condemns your house. The other problem with air property is that if you go back here and you see Cameron's living in there, and maybe Cameron's been paying the taxes and all of that on it, but he only has 8.3%. He has the same percentage as Cicely. And Cicely thinks, you know what, I am just tired of hearing about Cameron and that property. I just want to sell my interest in the property, okay? She can sell that to whoever she wants to sell. So let's say she decides to sell it to some person who has a lot of money or a developer. And so they can get her 8.3%. They're still only an 8.3% owner, but then that owner can force the sale of the whole property if they can't come to an agreement about how it can be sold or how it can be divided, or he can try to buy them all off. And so what happens, let's just say he does buy them all off, well, they have lost that family property and a source of wealth for that generation and future generations because of that one person deciding to sell that. So that's another reason you want to get it straightened out. And then how do you know if you own air property? Well, you probably know because people say you're living on family property. Yes.
Yes. How does that take effect if it's not deeded to that individual? How could that affect everyone else if they're not deeded?
Are you talking about the developer?
Yes, the person that
Well, Cicely can deed her 8.83 or 8.33 interest in the property. Even though it's not, she can't point to a part, she does have an interest in it. And so she could deed her interest, whatever that is, to that person. And then that person, it takes the risk of maybe, of what he ends up with. But if a developer is going to buy her 8.33 interest, they've probably already done like a family tree to see who all is involved and what they're actually getting. So is that what you meant?
Yes, but
Sorta.
would this only take effect if the heir passes away?
Well, the property doesn't pass until the owner, yes, I think that's the easy answer. So it's Pam and Peters, but Alexander is not going to have 50% ownership until they die. And even though, Benjamin has these 3 children, and he has the 25% interest, they have nothing. So they couldn't sell anything because they don't have anything.
Okay, thank you.
Yes.
I have a question because I'm in that situation right now. My mom and my dad both on deceased. All of my siblings have deceased. I'm the only living child. Okay, I was trying to get to that point that my father would put the house in my name, but we didn't make it to that point. So how would that affect me? I'm the only living sibling.
But did your siblings have children?
They have children.
It affects you. Yeah, you really need to go get an assistance from an attorney.
Yeah, that's what I'm doing.
And they're going to need to probate some estates. And so you are affected by that.
Okay.
So, and I'm just basing on what you've told me, so that I'm sure there's a lot more, that we will want to find out from you. But yeah, if they had children, and a lot of times it depends on when people died, where they died before or after somebody, but we can't get into all that. But yeah, that's definitely an heir property situation that you'll want to get cleared up.
And then I want to ask another question, and I'm going to end with another question that people might not know. Like, for instance, say mother, father, they divorce, father deceased, then the wife in the state of Florida come into her part too, along with the two children.
Well, here's what I'll say about that, is it gets real complicated because there could be multiple marriages, there could be children who are not a part of the one marriage, but were children of one of the people, and so they could all have varying interest in it, so it's very complicated. But it can be sorted. So that's the bottom line. It can be sorted. Yes.
If I may use her example, if parents are left a will for her, then she will be the sole owner of the house?
So if the will indicates that, then yes, that makes the process a lot easier.
So she would not be having to share it with anyone else in the family. It's just hers.
Right.
Yes.
Cool.
Yep.
But she would still have to probate that will.
Mm-hmm.
So just because he had the will that said you get everything, and that they can
We need it for the
certainly do that and
cameras?
cut out all the other
It's for the
children.
cameras.
But it does have to be probated to properly transfer the property. But yeah, you're not going to have to share it. Get
Yeah.
a will.
Yeah, no matter what, I mean, the answer is probate. So, if you want to make sure that there's no issue with clear title or ownership of the property, just make sure, things are probated. Yep. Yes, ma'am.
Can you give a quick definition of probate?
So probate is basically an administrative process to distribute the property, the debts, and the assets of the deceased.
And if that's after, so you have a will,
Mm-hmm.
and
And
how can you get it and bypass it being probated?
so having a will doesn't bypass probate. No matter what, you're going to have to probate. essentially. There is certain property that is exempt from the probate process, but you still have to, it gets a little nuanced. I don't want to confuse anyone, but you need to at least initiate a probate process no matter what is the easiest answer. Yeah.
And you're probably talking about, a lot of people try to pass their property outside of their will prior to their death. Like if you have insurance, you have a beneficiary, that's not a part of your probate estate. You may have already transferred the land to somebody and that you could take it out of your probate estate. So that's probably what you're thinking about. But like Jessica said, you still need to file what would be a really simple or a summary probate to clear up if there are debts or other assets that need to be distributed. I think we already talked about that.
Yeah. Okay. So we've definitely talked about some of the complications that come along with with heir property. So some of the benefits of having heir property and clearing title and making sure that the heir property passes correctly through the probate process is once you have clear title, it allows you to claim homestead exemption. It also just allows you to have control over the property. If you need to do repairs or anything like that, you have control over the property. You're also able to receive assistance in the event that we have, a natural disaster. For us, that's mainly hurricanes. For example, it allows FEMA assistance. And it also, just the sooner that you can probate and get clear title, it prevents a more complicated probate situation down the line. So a quitclaim deed. Do you have a more specific question? What is a quitclaim deed, or? You can get a quitclaim deed from someone if they are the owner of the property. There are different types of deeds. So a quitclaim deed is definitely one way to pass, the property easily, and it's probably the fastest way. It's not always the best way, but it is, it is an efficient way to pass property. But you have to, in order to receive a quitclaim deed, in order to receive it, you need to be getting the property from somebody who has clear title or ownership. And to give a quitclaim deed, you need to have that ownership or clear title. Yes, definitely register with the property appraisers. Yeah.
Hello.
Yes, sir.
Thank you for recognizing me. Is this on? Like good attorneys, the more you talk, the more the questions that come up, which some of them are very complicated, obviously, involving the law. What would be the advantages and disadvantages when you're alive of establishing joint ownership between two children and yourself, let's say? What would be the advantages or disadvantages to the two children, as an example, that now jointly own your house?
So I will tell you just off the top of my head, the biggest advantage is it will make down the road the probate process easier. And it will make things go maybe a little bit quicker, and prevents any unnecessary, family tension, or any, it just prevents any ambiguity, which could lead to tension, I guess is a better way to put that. The biggest concern with doing that comes to mind is if you are co-owners of the property, then you are also subject to each other's creditors. So you're opening yourself up to, other potential creditors. Is that clear?
Yeah.
Okay.
A bunch of issues. Homestead exemption is an example.
Yeah, and you can, you can still claim homestead exemption, if whoever's living in the home can still claim that homestead exemption. Yeah.
I'm assuming that, let's say you don't have a will, but the biggest asset you've got is your house.
Right.
You want to make sure that goes down real clear. And if there's three of us, we jointly own, I pass away, then you're down to two people, correct?
So.
Not talking about other siblings and cousins and what have you.
So in your situation, so it sounds like you and a spouse have one child, and you want to make sure, you want to make sure that property moves to your child as quickly and efficiently as possible. Am I understanding correctly?
Yeah, no matter how many children.
No matter
Take
how many
one,
children.
2, 3, whatever. But
Okay.
it goes to them, clears, no problems, no probate, as it
So-
relates to the house.
With or without a will? So without a will, what's going to happen, we have what's called in Florida an intestate statute, which basically just outlines, who the heirs are and how property is distributed when someone passes. So based on the intestate statute, the property automatically would be distributed. If both parents are deceased, then the property passes to the children equally. So, but with if you were going to go the route of a will, then, obviously whatever scenario you lay out in the will, that's what's going to be followed. Does that help clarify?
And when you pass like land or a house to your 3 children, you better hope they all get along really well, because that just can create enormous problems for them. If there's one that's just, a ne'er-do-well, or recalcitrant or won't sign anything, it may prevent one of the others from being able to do something, because there are other owners to the property that if they wanted to borrow money, they may have to get all of the owners. It's really most efficient and most likely to not create problems if you pass it to one child, but because you want the property to still be there. But if you don't care, you pass it to the 3, and then they may just say, okay, let's just sell it and we'll divide the proceeds among us, because nobody wants the house, but they all 3 own it. They don't want to have to deal with each other for the next, however many years. And so they'll sell it and then divide the proceeds. So if that's what you want to do, then, and you don't care that they do that, and you don't care that the family home still remains the family home, then you may want to do it to 3. But if you have an idea that you want that to remain in the family, then you may want to do it to the one person who seems most inclined to do that. Yes.
I'm sorry. Thank you. If the child is married, the one you leave in the property to, does the wife also have access to the house, or it's just him? Like if, let's say they're divorced or they separate, she will get half of the house, or it's just his? If it's in the will.
If it's just going to
that one child.
And then he later marries, well, that becomes a complicated divorce settlement agreement. So she may not get the home, but she may get some value from what she's put into the home. But that's a thing.
Okay, so we've talked a lot about how probate is how you resolve some of the issues that come along with clear heir property, or making sure that probate is the answer to making sure that you have clear title with heir property. So I'm going to talk more specifically about what probate is, what that process looks like. So just quickly, I know we don't have a lot of time left, but there are different types of probate. The two most common types of probate processes are formal administration and summary administration. So with formal administration, that is usually done within the first 2 years after someone passes away. It's got a few steps, so I'll walk through those steps. So first you have to identify the heirs that have an interest in the estate. In Leon County, there's a specific form when you do a probate called Affidavit of Heirs, and that's really, that form helps you walk through identifying the different heirs. So you'll file a petition for administration with the court, and you'll make sure all the heirs are served and have notice that, the probate is moving forward. And then you'll have a personal representative of the estate appointed, and they're going to be the point person, to make sure that the probate moves forward and is completed in an efficient manner. So you appoint the personal representative, and then you also have to wait 3 months to make sure any potential creditors, they're able to make a claim on the estate if they need to. And then after the 3-month period, you file an inventory, and you let the court know this is, what is specifically a part of the probate, or what, is currently needing to be distributed. And then you file a petition to determine homestead status. And then once you have an order from the court determining homestead status, then you can go ahead and distribute the property as agreed upon, or as the court has indicated in its order. And then summary administration, much quicker. You identify all the heirs, and then you file your petition for administration, and you file a petition to determine homestead status. And then once you have the order from the court determining homestead status, you can go ahead and distribute the property per the order. So I know that was lightning speed probate. So if you have any further questions, we'll also be outside at our table. So feel free to stop by and ask us questions. So, yes, ma'am. That's a great question. Definitely for formal administration. I would say probably for a summary administration as well, even though technically the court or the clerk's office might tell you don't necessarily need an attorney for summary administration. I think it's probably advisable. Yeah.
And last thing, if you think you own heir property, go ahead and do a family tree. Figure out who all the people are, get their contact information, address, their phone numbers, their email, if you know that. And remember, it's everybody. You saw with Pam and Peter and that crowd, there's a lot of people. So, and that when you do go in to talk to an attorney, if you qualify for legal services, you've already got that done, and we can get going right away. And we don't charge. But if you're going to a private attorney and they're helping you do that, you're going to be paying for it. Yeah. So it's better to walk in there and go ahead and have that done, save yourself some money, and save yourself some time on that. And if you're going to do this, and you're going to try to straighten it out, notify all the heirs. Hey, let's see if we can't get, Grandpa Peter's or Pam's property figured out, so that they know that, because nothing that makes a person madder than to get a letter from a lawyer that they weren't expecting. Mm-hmm. Yeah, go ahead and get started on that. Yes, ma'am?
Is there a service that will do a family tree for you?
You know what? You can go do Ancestry.com at the public library, and that will help you figure it out. There are services that do family histories and do that for you, but they are quite expensive. It's not like $100 or $200. It's thousands of dollars. So it's best, and I didn't realize you could just go to the public library and use Ancestry.com until just the last month or so. So that would be, because Ancestry costs if you get it on your own, but if you got the time to use it at the library or go online and use it at the library, you'll be saving lots of money.
All right, let's give them a round of applause. Thank you. right, up next in this.